This is the law of negligence, and I cannot explain how important your job is to learn negligence. Negligence will not only be the major topic probably in your Torts 1 final. Negligence on the California bar exam makes up 50% of the multiple choice. It's tested probably 80% of all bar exams in California. And if you're taking the baby bar as well, it's an area you just have to know cold. Many torts teachers will have whole final exams on the law of negligence. Now on Roman numeral 2, top of page 10, and it runs all the way, by the way, in the outline, all the way over to up to page number 22 of the, or 21 of the outline, and then we get into our defenses to negligence on page 22, 23, and 24. You have to have a good working knowledge of negligence, which I'm going to do for you today, and then you're going to have to practice writing your negligences under time pressure. The reason is if you come over here on the board, you'll notice that with negligence, it's a very large quantity of material that you're going to have to write on. In order for negligence, and by the way, negligence, just to give you kind of a point of reference, negligence means fault, okay? Negligence means fault. Most of our lawsuits in real life are grounded in the law of negligence. For example, auto accidents are based on negligence. If you are driving along and you're speeding and you go through an intersection, strike somebody in the intersection, that would be fault. You're negligent. It wouldn't be intentional. Intentional would be if you saw a rival gang member, you want to take them out, and you saw them on the street and you drove your car directly at them, that would be a volitional act with the desire to cause harm result. That would be a battery. But we're talking about generally are a fault standard. The results are unintended. So just mentally, when you think about negligence, think about unintended results. For example, a doctor who commits malpractice. A doctor does not intentionally want to harm his patient, but he might put in the wrong hip replacement. That would be considered what? Negligence. Let's talk about slip and fall. Let's say you're in a department store, and the department store has a broken chair, let's say a stair, and they are aware of it but didn't have time to fix it. Somebody falls down the stair. That's negligence, okay? So attorney fails to file the appropriate lawsuit within the time. He blows the statute of limitations. That's negligence. So our malpractice suits in the law are based on negligence. Most of your law in the area of medicine is based on negligence unless there's an argument for intentional conduct on part of the doctor. Auto accidents grounded in negligence, slip and falls grounded in negligence. So that is why a torts teacher is going to make sure that you're very well versed in the law of negligence, because when you become an attorney, most of your suits will be grounded in the law of negligence, okay? So what I'd like you to do for me, and I don't do this very often, I'd like you to memorize a paragraph for me, and this is on the top of page number 10, highlight Roman numeral 2A. Let's go through the memorized paragraph together. The defendant may be liable to plaintiff for negligence if it can be determined the defendant owed a duty of due care to the plaintiff, comma, the defendant breached that duty, comma, the plaintiff suffered damages, comma, which were actually approximately caused by defendant's breach, period. And notice that I have bolded for you duty of due care, or duty of care, breach of that duty, damages, actual proximate cause. That would be called the prima facie case of negligence. So when you sue somebody for negligence, the first two elements, duty and breach, that's the negligent act. Okay, so that's what you got to prove. That's the negligent act. Your C and D, and I'll do it in a different color for you because it's easier to see it that way. So I'll pull out my handy dandy highlighter here, and I will highlight 3 and 4 over here. That would be what we call causation. Okay, so that would be the cause. Okay, was the negligence the cause? And then finally, the last thing we're going to need the what? We're going to need the damages, and the damages would be the injury, okay, that results from the negligent act that caused the injury.